Good morning, everyone. I'm Ann Koontz. I'm with my partners, Jackie Durham and Marina Parkin. Today is February 16th. We know that you're still having the Valentine's hangover in love, so we thought you would love to hear all about part 2 of the asset purchase contract considerations. If part 1 didn't scare you enough and you've returned for part 2, you'll be delighted. Jackie has accumulated quite a list of more pitfalls and sticky parts of the contract to be aware of if you're considering buying or selling your business. So we've got quite a bit to cover today. As always, our webinars are recorded and they will be distributed for your viewing pleasure on our YouTube channel, on our Facebook page, and on Koontz Associates and KoontzParkin.com. You can ask questions at the bottom in the Q&A box. And if we think of something else after the webinar is over, you're welcome to email us follow-up questions or other topics you'd like to hear about. So without further ado, take it away, Jack.
All right, so I want to build upon sort of what we discussed in the first part. And this is going to apply in some respects to asset purchases, but also to stock purchases, because there's two different ways to acquire a business. And we've talked about sort of the pitfalls regarding the different ways that you can acquire a business in the previous webinar, so I'm not going to dive into all that detail. But pretty much what I'm covering today, a lot of these can fall into both stock purchase agreements and asset purchase agreements. And of course, it's really important. None of this is gospel. It's a starting point for your discussion with your attorney. So every transaction has unique facts and circumstances. And so what I'm saying today may or may not apply to your particular facts and circumstances, which is why you should always talk to your attorney first. So with that disclaimer, I'm going to jump into the first point. We previously discussed in the first part of the webinar how important it is to make sure you have an accurate description of the assets, especially when you're dealing with machinery and equipment. You want to make sure what you are contracting to purchase is what you're looking at when you're going through your due diligence review, because some folks can assume that the tractor over in the corner is what they're acquiring, when in fact it's the tractor in the back. The other item that I think is really important, and this came up in one of my recent transactions, and so I thought I might share it, is making sure that you're properly defining and describing the excluded assets. And this becomes particularly important whenever you have a seller. Say I, Jackie Durham, LLC, own 3 different restaurant locations, and I decide I'm going to sell off one of the locations, but retain the 2. If we have a sloppy description of the assets, if it's general enough, it can really describe all of the assets of the seller, not just the particular assets at that particular first location. So what can happen is you can inadvertently acquire title to assets that you did not intend to acquire title to, and now you're legally responsible for what takes place with those assets. So if there's an explosion in the kitchen, liability results from that. You may be tagged with liability due to that explosion, even though you inadvertently acquired title to that asset that you didn't even intend to purchase. So just want to mention that, because that can happen, because a lot of times in these contracts, at first glance, the description of the assets is very general, and it's fine if you're buying the assets of a seller from one particular or one single location, but if they have multiple locations, it can create problems and unintended consequences. So just wanted to make mention of that.
And of course, that won't happen because nothing ever happens to me. But I always tell people, Morgan & Morgan, for the other people, they're so busy and they're making more money than us because something happens to somebody. So as much as your explosion in the kitchen example, people go, oh, that will never happen. Like, that'll never happen. That happens to somebody because they're getting paid.
Yes, they are. And it's like an insurance contract again. An insurance contract is just a piece of paper until something happens and you really need it, and that piece of paper turns into gold. So you need to make sure that that piece of gold is solid. The other thing I want to mention is we talked about some of the contingencies involved in an asset purchase or stock purchase agreement. Particularly with a stock purchase agreement, if there is seller financing involved, in addition to the promissory note that you need to collect from your buyer, and in addition to the pledge of the stock that's being conveyed under the agreement, It's also really important for a seller in this position to also obtain a lien against the assets of the company. This is important because a lot of attorneys seem to think that a pledge of the stock alone is sufficient. I disagree with that because it leaves you as the seller open to the circumstances where the company or your buyer later decides to direct the sale of those assets, which you can't control and you cannot restrict. And that can thereby reduce the value of the stock, which you have a lien against. So you need a lien against the stock and the assets. So I just wanted to make mention of that as well. Another point that brings about a lot of discussion in my transactions is the allocation of the purchase price in an asset purchase. So this is something that I would typically recommend be agreed upon at the time you sign the contract, or at the very least before closing. But a lot of parties, and as many times when I'm only serving as the transactional closing attorney, and I'm not in a position where I can offer advice to either party because I don't represent them, many times those parties agree to allocate the assets after the closing. And this can lead to problems between the parties because they assume that this is just an afterthought. But it really has serious implications to the tax benefits and the gain that can be assessed to a seller on the assets themselves, because there are direct competing interests between these allocations to the tangible assets versus the intangibles. For example, a buyer is going to want the allocation to the tangible assets to be a little bit higher, whereas the seller is going to want it to fall on the lower end, or at least meet the depreciated value of those tangible assets. Well, the problem for the buyer in that circumstance is if you take that lower amount, now you have less to depreciate and less of a tax benefit to realize. And in addition to that, if you go to sell the assets on a later date, now your basis is lower and you have a higher chance of having a gain upon your sale of the assets. Marina, I know that you and I have gone back and forth about this in a number of transactions, and I've also done the same thing with Joanne. And I would love to hear your thoughts as well on this.
So on my end, where I see it is at tax return time. There's only a handful of clients where I actually get to work on this during the time of the transaction, which is great. So some of those clients have been trained by me, and they buy multiple businesses, and they reach out and say, here's the contract. What do you think about the allocation? Let's work it out. A lot of times they are taking a step to do it, even though the seller either may not care or will go with whatever they're doing. That's an exception, not the rule. A lot of times where I do see it is definitely at tax return time. So we're preparing a tax return. The client presents the purchase of the business, and then they said, well, where's the asset allocation? Oh, I have no idea what you even mean about that. Speak English, exactly. And then I start to explain to them exactly like Jackie said, for depreciation purposes, it's going to make a difference. And then I said, it's really important because the idea here and why it's so important is that IRS is going to try to match the allocation, because they don't want you to, both parties, to get the benefit by allocating the purchase price to different assets. So this is the reason for the agreement. There's a form that goes on the business's tax return to show the allocation of the assets, and it's really by class. They don't care about the, one truck or, piece of equipment, but they're going to say machinery and equipment, intangible assets, inventory. These are the types of classes that you need to show. So IRS is going to use that form on both the purchaser and the seller of the assets or in the business to really say, do they match? In my experience, this has not been an area that has been really highly audited. However, the stakes are higher when the numbers are higher. This is not, you're not buying, $200,000 business, and it really doesn't matter if you're allocating 50,000 here or there. It's probably the compliance of it is not as important, but the higher the dollar amount is, the bigger the impact is on taxes, the more attention it draws from IRS. And I actually, in fact, a few weeks ago read one of the notices that says that IRS is going to start looking at those asset allocation matches for purchases over a certain amount. Those are big dollar amounts, but it just says to me, made my ears perk up that they're really starting to pay attention. So this is definitely something that you want to agree on. And that particular form, you may want to fill out at the time of the purchase. And then if you're going to have a different CPA, or it's the CPA that's helping you. Now you've got a form that's ready to go. You show it to your CPA, that gets included in the tax return.
Perfect. And I think on the other side, if we're dealing with a stock purchase agreement, it's equally important to make sure that we are specifying what portion of the income and loss is allocated to the buyer versus the seller for the year in which the stock sale takes place. And Joanne, I know you've seen some folks run into some problems with that where it's not specified in the contract, and that can really lead to some issues because it can make a big difference from a tax standpoint for these parties.
It's huge, and it's just like when you build a new house, you want as much done by the builder before they get paid. It's the same thing. The seller is not terribly interested in helping you after closing once they've cashed their check and moved on from this business that they wanted out of. So it's not the time to be coming back and asking them to do you a favor. the time that they're going to care if you're happy or not is right before you pay them. So any cooperation that you intend to elicit needs to happen ideally before the closing. I had one recently that was a restaurant, and simple parts of this, signing the form to agree to the allocation of profit and loss with respect to the S corporation after closing took almost 6 months. I didn't handle the closing. I met the client after he acquired the business, and he spent a lot of money chasing the seller for something that should have been an email before closing.
Yep. The next item that I want to touch on, I think this is one of the most important items in a stock purchase agreement or an asset purchase agreement, and that's going to be the indemnification provision. It tends to be the source of the most discussion and negotiation between attorneys, and for good reason. It can prove to be one of the most important provisions in the contract. And in its most simplest form, the indemnification provision is really just one party, let's say the seller, agreeing to hold the buyer harmless for any claims that come as a result of the seller's ownership and operation of the business prior to closing. Sometimes it can also include indemnification for breaches under the contract, but that's all going to depend on how the provision is drafted. But I kind of wanted to go through and touch on some items that absolutely need to be included in the indemnification provision just to make sure it's enforceable and clear. The first is describing exactly who is providing the indemnification and who is receiving the indemnification. It goes without saying that the seller or the buyer would be indemnifying the other, but if you intend to include the principals of those parties, that has to be listed out. And that can make a huge difference. If I'm the buyer and I'm being indemnified only by the seller entity, if after closing that seller entity dissolves, I'm going to have a really hard time enforcing my indemnification claim. So I'm going to want to make sure the principals of that seller are also required to indemnify me as the buyer. And in addition to that, the buyer may also want to make sure that their principals and managers are the beneficiary of that indemnification requirement. In addition to that, the scope of the indemnity is pretty important. And by scope, I mean, not only are we talking about business operations and claims and liability arising from business operations, but also are we including defaults or breaches under the contract? That can become really important because there are certain clauses in these contracts that survive closing for a certain amount of time under statute or specifically under the contract itself. So that's really important, as well as defense. Sometimes these indemnification provisions don't touch on who's responsible for defense of the claim and who's responsible for paying for the defense. If I'm representing the party who is the recipient of the indemnification, I'm going to typically require that the indemnifying party pay for the defense, whether they appoint the defense or whether my client appoints the defense. But you want to make sure you specifically provide for that, because what can happen is if you don't specifically include that, you may be on the hook as the party receiving the indemnification to pay for the defense or to hire your own defense attorney. And those costs can oftentimes exceed the amount of the loss or the claim itself, which doesn't make a lot of sense, but folks find themselves in that position. You also want to make sure, depending on who you are, whether you're providing the indemnification or receiving the indemnification, you want to pay close attention to indirect damages, consequential damages, diminution in value of the business. If I am offering the indemnification, or my client is offering the indemnification, I'm going to want to limit those and exclude those specifically from what I'm required to pay out. However, if I'm receiving the indemnification, I'm going to want to include the consequential and indirect damages to make sure that I can recover as much as possible in the event a claim arises. Another item that can often lead to problems is there is language, and it can really just be a few words that can make a huge difference. Depending on how the clause is drafted, sometimes a party is required to indemnify another party for that second party's own negligence, which doesn't make a lot of sense. Most parties think that they're only going to be liable for what they have actually caused. But if the indemnification clause is not drafted carefully, you can end up, you can have a situation where seller is 60% at fault and buyer is 40% at fault, yet the seller's holding the whole bag at the end of the day based on how the indemnification clause is drafted. So it's really important to make sure your attorney is taking a close look at exactly what's going into that paragraph. And I can tell you, I've spent hours at a time negotiating just this one little paragraph, because these items are crucial and can make a huge difference. A few other items really fast with the indemnification clause that I want to touch on. Notice, you want to make sure it's very clear what kind of notice has to be provided and when. Also, the amount that's being indemnified. Sometimes parties to a contract will negotiate deductibles and caps on the indemnification. Deductibles is the minimum baseline amount that has to be incurred in loss or liability before the indemnification obligation is triggered. And a cap is, just as it sounds, a cap on the total amount that the indemnifying party has to pay out under that clause. These particular provisions and caps and deductibles can also form a part of the basis of the bargain, in my opinion, and the parties need to consider this whenever they're negotiating the purchase price. Because if I'm buying stock and thereby stepping into the seller's shoes and assuming all the liability of the seller based on the prior operations of the company, I'm going to want that indemnification to be as broad as possible. And if my seller is trying to put a cap on that indemnification, well, that really should rightfully affect the offer that I'm putting forward. So it's really important to take a look at those items and to discuss them in some detail with your attorney. And then lastly, another item that's really important is to describe what triggers the indemnification obligation itself. Is it simple notice to the other party, hey, I'm entitled to indemnification? What if there's a disagreement about whether or not you're actually entitled to that indemnification? Sometimes it requires a court order. Sometimes it requires a final non-appealable court order, which if I'm representing the indemnifying party, of course, I'm going to require that. Whereas if I'm representing the party who is receiving the indemnification, I'm going to want that trigger to be as lax as possible. The other thing is the manner in which the indemnification is paid. There's a lot of different ways that this can shake out under the contract. Sometimes it's just cash that's required to be paid within a certain number of days of either the order or the notice. Under the contract, you can also draft and provide for an escrow holdback, and that escrow holdback can be applied to any indemnification obligation that arises within a certain amount of time. Also, if there is seller financing, many times what's baked into the contract is that the buyer can offset payments due under the note if an indemnification obligation arises on the part of the seller. What you need to make sure you're carefully providing for and thinking of, though, is if you're the buyer, you're going to want to make sure that you're specifying that that offset can come off the front end of the note, meaning the next payments due under the note, versus if I'm representing the seller, I'm going to say, seller, I want to make sure that if the offset obligation occurs and the buyer can offset their payments due under the note, that we're doing this in the reverse order of maturity and they're coming off the back end of the note. So it can really be crafted a bunch of different ways depending on who I'm representing. But these are items that it's really important to think about when you're reviewing this and negotiating this. Some other items that are really important to incorporate are if there is insurance proceeds that are obtained and applied to the claim itself, you want to make sure that the indemnification claim is reduced by that amount. So if I'm the seller indemnifying the buyer and the buyer carries a liability policy and that policy covers a portion of the indemnification claim, we don't want the buyer to be able to double dip. We also want to make sure that if a party is delayed in notifying someone about the indemnification claim, and it causes additional loss, that additional loss should also come off the top of the indemnification claim. Because rightfully so, if there's a delay and you otherwise could have avoided that additional loss, it should be mitigated. And there also should be included in that clause a specific requirement that there be some kind of reasonable commercial efforts to mitigate any claim or loss. So if I'm the seller indemnifying the buyer and the buyer just sits by, and they could have done something to mitigate the claim, but they just chose not to for the heck of it, and it increases the loss or liability, or the loss or liability could have been mitigated in some manner, they shouldn't be able to claim that full amount of indemnification as a result of just standing by, essentially. Do you guys have anything to add to that?
That is one of those things that is dry and dense and terrible and very easy to think doesn't matter. And this is Marina's favorite line, devil's in the details. This always comes up when there's a problem. So when there's no problem, it's great. But we've seen these things. We had a situation, again, we were not the closing agent. Someone bought a restaurant with trumped up financials. There was a lot of litigation ensuing. And then now the litigator is very interested in what this indemnification provision provides. Meanwhile, the buyers and sellers paid no mind to it, if there even was one.
Yeah. And, you know, I just spent 15 minutes going through what can be a paragraph that is this size.
Yeah.
And I can jam it all in there, and my paragraph's going to be a little larger. It's going to exceed the size of the screen. But at the same time, in one page, you can bake in what is essentially an insurance policy, or akin to an insurance policy. So again, that's why I think it's the most important one. Something else that's really important under these contracts are the representations and warranties that are provided. Of course, the buyer provides some, but most of the weight comes in the seller representations and warranties. So buyer, you're going to want to pay very close attention to these. They typically confirm the valid entity and good standing of each party, the absence of liens, the quality of title, the absence of litigations or claims. And this is really important, the absence of litigation. I want to mention this one because it's definitely on the forefront of parties' minds whenever they're buying stock. But there's this misconception that if you are buying assets, that you have nothing to worry about, even if there are certain claims against the seller, as long as there's not a judgment or a lien against those assets. And we've had some pretty lengthy discussions with asset protection attorneys who have warned us and guided us that if there is a pending action, or even if there is a threat of action, if you are a buyer and you acquire assets from the seller who has a potential action or a pending action against them, even though there's no judgment yet and no lien against the assets, that could still come back to haunt you later, and that plaintiff creditor could still attempt to lien or attach those assets. And that claim may or may not be successful. It's not going to be a strong claim on their part, especially if you paid fair market value for those assets. However, it's still going to be your problem. You're still going to have to pay an attorney to fight it and to remove the claim of attachment from your assets, regardless of whether or not you had anything to do with it, and regardless of whether or not it's a valid claim or not. So in that instance, you really want to pay close attention to any kind of pending action against the seller in the context of an asset sale, because it could eventually become your problem. And I've had parties in this situation where buyers have requested an escrow holdback to basically cover them in the event that the litigation goes sideways and they ultimately face a claim like this from one of the seller's creditors, because you will have to pay out and it could ultimately become your problem. So it's important to just kind of talk with your attorney and figure out if that's a risk you feel comfortable assuming, or if you want to request some kind of holdback.
And Jackie, to jump in here real quick, this is the kind of stuff too that we look at when we do any due diligence work, even on the financial side. Yeah. Other than just, you know, tracking the trends in revenue and overall expenses, we do look at what makes up different expenses. And oftentimes this is where this kind of stuff gets discovered. Let's say the insurance expense goes up, and oh, we had an action and the insurance had to pay out. Well, it means there may be, is there anything else that this is leading to? And legal fees is one of the biggest expenses we look at. What happened to the legal fees? Why did you have such high legal fees? Oh, I was fighting off something and there is nothing happening with it now. Well, let's, dig a little deeper and see if that's the case. And this is why this kind of due diligence, even though, just like you said, Jackie, even though you may be buying assets and you say, I'm not buying stock, I'm going to make my own money, with these assets. But sometimes these due diligence procedures in looking at expenses and the trends can uncover some of that other stuff that will affect your claim to these assets.
Right.
And not only is it attorney's fees, we also see something's up when insurance premiums jump, decrease. So you either stripped coverage to make it cheaper, to make you look more profitable, or you increased coverage because you were underinsured and now you have a right amount, or your premium went up because you had a huge claim. Either way,
exactly.
we see that when it comes out on the other side.
Yeah.
Exactly. And another thing that I'll just mention is when you're weighing the risks associated with this pending action or potential action that is surrounding your seller, you as a buyer also need to think about the fact that you're buying these assets now, but you may not want to hold these assets for the rest of your life. So if there is any kind of claim of attachment that your seller's creditor makes against the assets, whether it's right, wrong, or otherwise, and whether it's eventually going to get removed, it's not going to go away right away. It's going to take some time and money to get that removed. And in the meantime, your assets are not marketable as a result of that attachment. So just keep that in mind. There's a bunch of different factors that can go into that and whether or not it's worth the risk. It's also something I want to mention. There's a bunch of other reps and warranties that can go into each contract, and it's really going to vary on a case-by-case basis depending on the particular facts and circumstances of your transaction. But if you are a buyer and you have a seller who is reluctant to extend some of these traditional representations and warranties, you need to take a close look at that because there's likely a reason why. And in addition to that, it needs to, again, factor into the offer you're making, because in addition to the value of the assets, the basis of the bargain also needs to go into the indemnities you're receiving, the restrictive covenants you're receiving, and also the quality of the contract. Because if you buy assets or stock and there's minimal representations and warranties, now your recourse against the seller after the fact is going to be very limited. So just keep that in mind. Now, I kind of want to touch on a couple of different things that are go-to requests that I make for a buyer or a seller in a stock transaction or an asset transaction. If you're a buyer, you're going to want to make sure that the representations and warranties that the seller are providing are also restated and reaffirmed in the seller affidavit, because you'll be surprised to see how quickly someone is to sign a contract with certain representations and then how spooked they get when they're signing under oath in an affidavit. It can make a difference. Also, again, I was speaking earlier in the webinar about how you really want, if you have a seller selling their assets and it's an entity, you also typically want to request that the principals of the seller also sign off on the contract. It's going to be a more comprehensive protection, and now you have an entity and two individuals making these representations and warranties and offering the indemnities and things like that. It's just more comprehensive. Also, there's a standard clause that I include at the end of the representations and warranties of the seller, especially if I'm representing the buyer. And this is basically that there's no omission of any material fact which could affect the value of the stock and or the assets. And you want to make sure that's sort of a catch-all to make sure that the seller is really taking a close, hard look at what they're representing to make sure it's accurate. Because if they fail to include something that needs to be included there, now they're in breach of the contract. And finally, if I'm representing the buyer, you want to make sure that the representations and warranties survive the closing for the maximum statutory period of time. Your seller, on the other hand, and if I'm representing the seller, I'm going to try to limit that period of time to 6 months to a year, because I want to cut off that liability at some point. So there's going to be some push and pull there. That's pretty common. If I'm representing the seller, I'm going to want to limit the representations and warranties to the actual knowledge of the seller. And how that is defined, it's commonly referred to as the knowledge qualifier. How that is defined is absolutely crucial, because what you want to ensure if you're the seller is that principals or owners of the business who don't really have direct knowledge or have no reason to have that direct knowledge, that they're not going to be on the hook for qualifying that knowledge. So you're going to want to limit the knowledge to somebody who's actually been involved in the business when it comes to that knowledge qualifier. And you're going to want to state very clearly in the contract that the representations and warranties are to the best of this particular principal's knowledge, just to limit that scope of liability. And in addition, on the flip side, I just said how if I'm representing the buyer, I want the seller and all of their principals to sign off on the contract. If I'm representing the buyer, I only want the seller entity signing off on the contract. I don't want all of the principals of the seller signing off on the contract, because those are additional individuals who are signing on to that liability. So again, it can really look different depending on who we're representing in the transaction. The other item, the one final item I would say, when it comes to a seller, you are going to want to obviously be as truthful as you possibly can to the best of your knowledge in the representations and warranties you're making, but you're also going to want to include at the end of these reps and warranties something that states that other than what's included in this contract, you have not warranted or represented anything else. Because there can be a lot of discussion leading up to the contract between the brokers, the parties, their attorneys, and a lot of information that gets thrown around. And you really want to make sure that you're very crystal clear that you're only warranting and representing what is within the four corners of that contract. And again, the accuracy of these representations and warranties is something that I typically include as a condition to the buyer's requirement to complete the closing. So, and the reason why I include this is if you get outside of that due diligence period, let's say due diligence has expired, you no longer have the ease of terminating the contract for any reason. Once you're outside of that period, if you stumble across some information that renders one of the representations made by the seller incomplete or inaccurate, and it gives you concern to the point where you don't feel comfortable proceeding with the closing any longer, depending on what the default language says, you may not be in a position to just at will terminate the contract. You may have to sue the other party to terminate the contract specifically. So if you have that built-in condition, that's your way of pulling out if one of those reps or warranties turns out to not be true before closing. So another little angle that I wanted to throw in there. Do you have anything to add to that, Joanne or Marina?
The problem is, the next part of this that I want to add is, well, I guess maybe I should do his summary, but this is the problem with signing something and then sending it to us. Well, there's an attorney review provision. Well, but once you've already agreed, there's a lot of this we can't go back and change, or it's difficult to get the other party to allow that change, because now it looks super lawyered up, instead of if we got it before and it's just the first draft that went over. Because why are people look at us suspiciously, like, why are you milling around in these provisions, in these boilerplate mundane provisions? What they expect you to be fussing where there's time frames and deadlines and deposits and closing dates. Nobody wants to see Jackie with her enormous red pen lurking around the indemnification provision. Like, nobody wants that. So if they see that, the hair on their neck goes up, like, ooh, what's this lawyer doing? And that's where the jokes come from, right? Like, we're just here to blow up the deal. Like, no, we're here to protect you. And I'm not suggesting that we do it surreptitiously and like on the sneak, but all of these provisions, particularly this last three that you've covered, are more, I hate to use the word mundane because they're so important, but they're much more subdued in their visibility in the contract because it's a big block of words, and frankly, people don't have a tendency to read them, including the business brokers. Well, so everyone's just like, oh, that's just standard. Oh, okay, well, standard is not good for you necessarily.
Right. Well, and it's basically written in a different language. I mean, for God's sake, when I'm reading it, I'm like, ugh. So can you imagine somebody who hasn't gone to law school and who hasn't read, 10,000 contracts, trying to read through and understand this crap, including the poor brokers? Like, That's why they have no business reading through here and trying to understand this, nor should a party. Like, you really should have your attorney read through that, because that's the only way that one of these little gotchas that are hidden and buried in all this legalese, this is the only way that they can really be uncovered and addressed.
And really, not just any lawyer, a lawyer with experience specifically in these types of transactions. We see it immediately if somebody on the other side doesn't do this all day, because their questions or their comments back to us don't make sense. You can see immediately, like, oh, you don't do this very often. Oh, you're a family lawyer doing this. Great. That's great. You are a lawyer. But if you don't have experience in this, you don't want your first date with somebody being in a transaction like this.
Absolutely not. Yeah, I could not agree more. So I guess on to the next part that, this is actually a part that's interesting that some people will pay some attention to, and that's the restrictive covenants, such as the non-compete and the non-solicitation. One thing I just want to mention about this is that that's a whole other clause that would require very careful and close consideration, especially based on the particular circumstances of your business. But what I will say is continuously, I see these clauses that really just speak to competition of the business. And that's not enough. That's really falling short of what you need as a buyer to protect yourself. You also need to have a restriction against the solicitation of employees and customers. You also need a restriction against disclosure of confidential business information and trade secrets. That confidential business information and trade secrets, for a lot of businesses, is what is some of the strongest essence of the value of the business itself. So if you are a buyer and you pay all this money for this business, and then your seller turns around and shares this information with third parties or the public, that could really hurt your business. Likewise, if you have certain key employees who are plucked by the seller, even if they fall outside the scope, the non-compete territory, that likewise could also really, really hurt your business and the continued operation of the business. So it's really important to take a close look at that and make sure all your bases are covered. In addition, the non-disparagement clause is something that a lot of people look over, and it's not something that's too much of concern, and that's typically because at the beginning of the transaction, everyone is shaking hands and going to dinner and getting along great, but things can deteriorate quickly. And by the end of it, you want to make sure that the other party is not in a position where they can say what they want about you on Facebook or elsewhere or at a cocktail party. Because that can damage your reputation as a party. It can also damage the business. So making sure all those bases are covered, and also making sure that any information that's exchanged between the parties and while the transaction is pending, that is deemed to be confidential information that can't later be disclosed or utilized to the benefit of the other party. So if I'm the seller and I'm letting you look under the hood, buyer, and you're seeing all my trade secrets and my methods and processes and recipes and what have you, you better be sure that you're having that buyer sign a Loctite agreement or have something baked into the contract itself saying that the buyer then can't use that information to compete against you later should they elect to terminate the contract or turn around and sell that information to someone else. Any comments on that end?
To take that a step further, that's great for the contract, but you also, if you are the seller, want to make sure. I've had a couple sellers be solicited when they were not listed for sale by a competitor who's just saying, hey, I'm interested in buying you, as a way to have a peek under the skirt to see what's going on. And if you don't have the appropriate NDAs and disclosures on the front end, if you pull something off Google, it's probably not going to protect you. But people feel like NDAs are like, oh, I'll just get one. Like, well, but what's in it? What's protected? And what, more importantly, how do we determine damages if there's a breach? Because everybody who likes to do their own agreements is really good at putting in there what they want to happen. But they're really bad at putting in there what happens if it doesn't happen. What are the damages? What are the defaults? And what are the remedies? And when it doesn't go according to plan, that's what's missing when people DIY their legal documents.
Right, and
that's always missing.
And that's the perfect segue to my next topic, which is the default provision.
Oh,
thank you.
It's like we've done this before.
Right. So the default provision, again, it's one of those that falls towards the end of the contract when you are fatigued from reading, but it's really important. And I would say that it's one of the more lacking provisions, in that it oftentimes describes where you bring the action, which is the venue, what are your remedies, but many times it doesn't include under what circumstances the parties have a right to terminate the contract. And this can be problematic because unless you reserve a specific right to a party to terminate the contract upon the default of the other party, then they're not in a position to cancel the contract even if the other party has defaulted. They are restricted to what is in that default paragraph as to what their recourse is. So you can find yourself in a position where the other party has clearly defaulted, no one's disputing that, but you now have to go to court to get an order to judge that the contract be terminated because the other party is being difficult and just won't sign the termination of the agreement. So it's really important to bake in that particular right, whether you're a seller or a buyer, to be able to elect to terminate the contract without taking any further action. Cure periods also need to definitely be more carefully incorporated because a lot of times the way they're drafted, it's not necessarily clear what the cure period is and who it extends to. Provisions that survive the termination of the contract are also really important. Like I was just saying about the non-disclosure and the confidentiality about the information that's exchanged during the contract, that needs to survive the termination of the contract because the contract doesn't always get to closing. And a lot of times the provisions are stated to survive the closing, but not necessarily the early termination of the contract. So you want to make sure that's baked in as well. The disposition of the deposit really has to be one of the most important things that is provided for under the default provision. And a lot of times parties just assume that the deposit will go to the other party in the event of a default. But unless it's specifically stated there, that's not always clear. And for a seller, it's particularly important that you have a liquidated damages clause in the contract if you're going to seek to retain that deposit. If you don't have a sufficient liquidated damages clause, the retention of that deposit could be deemed a penalty and unenforceable ultimately. So it's really important to make sure that language is sufficient and included. Steps to address the dispute is also really helpful. You want to make sure not only are you electing the venue where any action needs to be brought, and the venue means the particular county where the parties are permitted to bring an action, but if there's any prerequisites to bringing that action, such as mediation. I'm a big fan of mediation. I do feel that sometimes when parties just get across the table from one another and they get their brokers and attorneys out of the way, there can be pleasant resolution fairly quickly. Because sometimes the telephone game can get in the way. On the other hand, arbitration is something that I'm increasingly seeing creeping into these contracts, and it has its pros and cons. If you are if you're looking for confidentiality and you don't want your name in the public record, arbitration could be very attractive to you because it's not public. It's not like a circuit civil case that is filed where the names of the parties are going to be there for the next 20 years. It's confidential. So that can be attractive to certain parties. But at the same time, if one of the parties is really, really pushing for arbitration as the other party, I might be a little concerned because it's like, why are you trying to keep your name out of the public record? Are you involved in lawsuits with some frequency? So you kind of want to think about that. And some of the other pitfalls of arbitration are that it's very difficult or more difficult to appeal rather than a typical court decision. And in addition to that, the pool of attorneys out there that are available to represent you in an arbitration is a bit smaller because not every litigation attorney participates in arbitration proceedings. So your available pool of attorneys might be a little more limited. So those are just some of the pros and cons of those different kinds of provisions.
And the cost really isn't less than regular litigation. I think that's how it started, was that this is an alternative to being in court, but really there's really no cost savings now. So you're not really picking up a benefit.
Right, right. One of the last items I wanted to touch on, it's sort of a gotcha clause that tends to be hidden at the back of the contract. And I've seen it several times now, and it's something that at first glance, it doesn't seem that spooky until it actually applies to your facts and circumstances. And it's essentially a waiver clause whereby one of the parties, typically the buyer, is basically representing that they're not aware of any breach by the seller under the contract. That all of the, to their knowledge, all the representations and warranties of the seller are true and accurate and correct. The problem with this is, and also in addition to that, to the extent they are aware of any breach of any warranty or representation, that they are waiving that breach of warranty and representation at the time they close. The problem with this is, when you as the buyer are collecting information and due diligence, if you come across something that might suggest that maybe there is a breach of a warranty or representation of the seller, and you don't raise your hand and terminate the contract, it's basically speak now or forever hold your peace. You will not be able to come back and pursue that seller for that breach of representation and warranty based on that waiver provision. And where I've seen this is in a stock transaction, we did some due diligence. There were some prior transfers of stock and they were not done well. So the buyer's in a position where they're like, okay, well, you know, I guess I'm willing to proceed and buy it, even though there is some chance and some risk that the prior owners of the stock could come back at me later. I have the reps and warranties and I can just sue the seller later should I have any claim to the stock, because it's a breach of their representation and warranty that they have free and clear, good, valid title to assign to me. Well, the problem is if you have this waiver provision hidden at the back of that contract, now you can't come after the seller after the fact should those prior owners come and make a claim against your stock. So that's just one practical example of how that can happen. And I'm telling you, this waiver clause is like 4 sentences long, very unassuming, very easy to miss. And of course, at the back of the contract where you've reached when you're fatigued and sick of reading. So
you've even got that.
So that's all the scary news that I had to share for today. I didn't want to dive too much into the minutia, more so than I already have, because folks can only take so much. So.
Well, what a Valentine you are.
Yes.
I did want to mention something, Jackie, as well, from kind of chiming in on my side as the CPA. Oftentimes, if our law firm counterpart does not do the due diligence or the transaction closing of the purchase, and it's just the client we get on the tax side, and they bring me this agreement and they say, can you take a look at this agreement? I bought this business, I bought stock, or I bought assets. Can you just look at it and tell me if it's okay? And did I do everything? Your CPA will only pay attention to the things that we need for the tax return, like the asset allocation, who is the new owner, what's the ownership percentage, who contributed how much capital. These are the things that need to be reflected on the tax return. But when we're talking about these particular clauses, really things to protect you as the buyer or you as the seller, these are the things that absolutely have to be reviewed by an attorney. You cannot cut corners by showing it to a CPA. We know these provisions exist, but reading the verbiage is not going to tell us one way or the other if it's drafted properly, if it reflects your situation, and if it's something that even is applicable in your particular case. Maybe it was a boilerplate agreement that you copy and paste, and some names even forgot to be changed. So you cannot rely on the CPA, which we've seen before. And this is why it's stories from the ground kind of thing. And this is why I always tell my clients, look, you need to have an attorney take a look at it from the legal standpoint, and I will chime in on the tax side. It never fails.
Absolutely.
Or stories from the underground. It is true though. It's like, well, while I'm at the knee doctor, can you just take a look at my tooth? Like, no, wrong doctor.
Right.
Just because I'm good at some things, I'm not good at all. So
yeah, exactly.
Wow. All right, ladies, I think I'm going to let you off the hook today. For those of you who do think of questions, like I said before, after today's session, you're welcome to email them. We will be back to you next Tuesday. We are back with our next part 2, which is what to do if you would like more sales with John Cipher. So once you get the business, if you'd like to grow it, tune in next week to learn more about how. And if you have topic ideas, please feel free to share those with us as well. We appreciate your time. Thanks, ladies.
Thank you.
Bye-bye.